Good morning and welcome to an oral argument session of the Fifth District Court of Appeal. My name is Rand Wallace and I will be presiding over this oral argument at 9 o'clock on Zoom. Joining me on this panel are Judges Paige Kilbane and Judge Jordan Pratt from Duval County. And the first case we have, or the only case we have on the docket for Zoom, is Don K. Jervin versus DCS Real Estate Investments. And I'm going to assume that the appellant wants 5 minutes for rebuttal unless you tell me differently. And I think, is it Mr. Levy? Is that correct?
Yes, Your Honor.
Okay. And please just make sure that if you have any devices that will make noise, please make sure to silence those or turn them off so they don't distract the parties from making their presentation. And you can also mute your microphone when you're not speaking. And yeah, that's really all the instructions I have. And with that, Mr. Levy, I will be quiet and let you begin your presentation. You may proceed.
Thank you, Your Honor. Thank you, everybody. So we are here today to deal with a denial of a motion to dissolve a temporary injunction. The underlying lawsuit is for defamation and tortious interference with a business relationship. After the lawsuit was filed on February 28th, 2018, a temporary injunction was entered, which bars Mr. Jervin from certain protected speech online. Specifically, he is precluded from tagging, associating, or linking plaintiff with any current or prospective customers, or posting anything online which uses the terms mafia or bully to describe the plaintiffs.
Counsel, you used the phrase protected speech. Would you concede that speech that tortiously interferes with a business relationship is unprotected?
In certain instances, Your Honor, yes, I believe so. And I guess what
Is it also the case that in the initial injunction, the court found that the plaintiffs were likely to succeed on the merits of their tortious interference claim?
Yes, that is correct, Your Honor, in that initial finding prior to entering the injunction. And that was back in February of 2018. So we're about 6.5 years later now at this point. During the course of this litigation, Mr. Jervin served discovery requests on the plaintiff saying, give me everything you have that shows there was any damage to your reputation, that there was any financial loss from any statements that Mr. Jervin made, that Mr. Jervin had any knowledge of the business relationships with any of these third parties, and any other documentation or information you have to support the claims in this case. In response to that, after a motion to compel, they produced some emails and text message exchanges. It's difficult to tell if they relate to one potential sale or more than one potential sale because they redacted a lot of the information in there. But all of the emails and all of the text messages that were produced refer to litigation that was ongoing at that time or that had recently been dismissed at that time. That had involved Mr. Jervin and other homeowners in the community. Not one of those emails, not one of those text messages, not one of those prospective buyers says, I was contacted directly by Mr. Jervin. Not one of those emails or text messages say, hey, I saw that Mr. Jervin referred to you as mafia-like online, so I'm not going to go through with the sale. Nothing said, hey, I saw him refer to you as bullies online, so I'm not going to go through with the sale. There's absolutely no evidence that has been presented. And again, we're 7 years into litigation. If this information existed, it would have been produced by now. It would have been required to be produced. They have a discovery obligation. So,
Mr. Levy, we're here on a motion to dissolve the temporary injunction. Is that correct?
Yes, Your Honor.
Okay, so the temporary injunction was put in place by the trial court. Sounds to me like you're arguing as far as the sufficiency of why it should have even been put in place as a temporary injunction, but it was put in place. So isn't the burden on you to prove a change in circumstances in order to dissolve or modify the injunction?
So No, Your Honor. So let me answer it two ways. So no, I don't believe it is, and I'll explain why in a moment. But B, I believe we have shown a sufficient change in circumstances. But there's a Florida Supreme Court case, Planned Parenthood versus MMB Properties, a 2017 case that says requiring a threshold showing of changed circumstances when moving to modify or dissolve a temporary injunction is incompatible with equity principles when a party shows clear misapprehension of the facts or clear legal error on the part of the trial court in entering the temporary injunction. So we believe we have that standard here. There's not an obligation in every circumstance to show changed circumstances. But to my latter point, I believe we did sufficiently show changed circumstances, and that now we are 7 years later. So the trial court at the time, has to make a decision relatively quickly based on the information that's in front of him. That was 7 years ago. Since that time, they have failed to produce a single piece of evidence that shows a single dollar was ever lost because of any of these enjoined statements. And that is their burden. They have to maintain the temporary injunction. They are required to show an actual deleterious effect on the business from the enjoined statements, or the injunction cannot be maintained. That comes from Cheveldina versus RK Florida Management, a third DCA case. So that's what's required to be shown here. And again, the change in circumstances is we asked them, show us what damages were ever caused by these enjoined statements. Show us what harm was ever caused by these enjoined statements. Show us that Mr. Jervin ever had knowledge that any of these prospective buyers were actual prospective buyers. And they've produced absolutely no evidence. The other thing, so that's the first thing. So they have to show that actual deleterious effect on their business. Temporary injunction is not available for defamatory statements. That's been held time and time again because there is an adequate remedy at law, money damages. And that you cannot meet your burden by showing communications to the public at large, right? So that comes from that same Cheveldina case. You have to show that there was a knowledge of this business relationship with a third party. You have to show that there was an intent to interfere with this business relationship. And they simply have not done this here. Again, the only evidence that they've ever submitted of any impact, potential lost sales, relates to the filing of a lawsuit, which is not at issue here at all. There's nothing to show that Mr. Jervin ever had knowledge that any of these people in these emails or text messages were prospective buyers. If you read them, it is abundantly clear that he never contacted them directly. Most of them say they saw things about the lawsuit online. And the only kind of vague reference to Mr. Jervin is made by employees of the plaintiffs who say, oh, this guy contacts local news and he does all this ridiculous stuff. None of them say that he contacted them directly. None of them say, again, any of the enjoined statements. And that's also key here, Your Honors, because they have to, the deleterious effect has to be based on the enjoined statements. So we have someone who for 7 years has been precluded from exercising his First Amendment right to free speech online, right? Who has been enjoined from doing these things. And there's never been any evidence of any harm whatsoever. And this is one of those, what I would classify as a prior restraint on free speech, which the U.S. Supreme Court has said is the most serious and the least tolerable infringement of First Amendment rights. And we have that most serious and least tolerable infringement with absolutely zero evidence of any actual harm, any intent, any knowledge, anything that would be required to meet the burden for intentional interference with the business relationship.
Well, counsel, aren't we looking at, because again, this is for a motion to dissolve, as Judge Wallace mentioned, aren't we needing to look at, in addition to the change in circumstance, who caused that, and if that can be attributed in any way to both parties or just to one party? I mean, there's some indication in the record that, your client may have caused some of this as well. Does that have any impact here?
Are you referring to the length of time that it's been in place, Your Honor?
Yes, you've made several references to the length it's been
Yes.
there. So does that have any impact?
Well, Your Honor, not in the first argument that I was making, which is that there's just been no evidence at all to show a deleterious effect. But yeah, so the second argument is the length of time in and of itself should lead to dissolution of the injunction. So to answer your Honor's question, to a certain extent it can, right? If both parties are responsible for the delay. If you look at their answer brief, what they say is, well, he filed for bankruptcy, that led to a 7-month stay. He did go through some attorneys, that didn't lead to any appreciable delay in the case. And then he's had appointed counsel from his insurance company. His insurance company went insolvent, that led to an automatic stay. But when you look at that in total, it's pretty small compared to the 7 years. And I think the bigger issue is—
What about the appeals? He has a right, obviously constitutional right to appeal decisions from the trial court, but there were 5 appeals associated with this case as well, that contributed to the delay as well, correct?
I don't believe it contributed to the delay, Your Honor, because it would not have been none of those appeals. So he was sentenced to jail twice for violation of the injunctions. I think another time he was found in violation of the injunction, so appealed those. That wouldn't have delayed progressing the underlying lawsuit, though. That only dealt with the finding of the violation. I did have to file a writ of prohibition in the court when the insurance company went insolvent to get the trial court to stay the case as required by law. And then we're here today. But there's nothing precluding moving the underlying action along. And I think if you look at the record in the trial court, it's abundantly clear that the plaintiffs never took any steps and never wanted to take any steps to actually litigate the case. They've amended the complaint 4 times. They've sought to enforce the injunction 4 or 5 times. They served initial written discovery way back in 2017 or 2018. Since that time, haven't done anything. They haven't, as we sit here today, they haven't even taken a single deposition in the case. To me, it's very clear that the goal here is they got that injunction. They want to keep that injunction in place. They want to enforce that injunction. They want to continue to restrain Mr. Jervin from being able to exercise that First Amendment right. And again, I do think that the record shows that the plaintiffs have been grossly negligent in progressing the cause. They haven't taken any steps to move the case along besides amending the complaint and amending the complaint, amending the complaint, and churning the wheels to keep this matter going, Your Honors. So,
Counsel, if we could just step back real quick to your first argument about the sufficiency of evidence or insufficiency of evidence supporting the initial entry, essentially, of the injunction. The trial court found, when it entered the injunction, that there was a likelihood of success on the tortious interference claim, right? And as I understand it, your beef is with that original determination with the initial injunction, that the evidence that had been brought forward at that time was insufficient. So one of the things that that I'm concerned about, and I'm hoping you can help me, is, if we allow appellants to revisit essentially the initial injunction when appealing a motion to dissolve, right? Aren't we sort of allowing an end run around the appellate process for that initial injunction? Because your client had the opportunity, right, to appeal that initial injunction. So how would ruling for you allow us to maintain the distinction between appealing the initial injunction and then appealing the motion to dissolve? Because I think those things are separate, and they're supposed to be separate, right? You're not supposed to get 2 bites at the apple. So how do you cut through that for us?
So 2 points, Your Honor. So I do believe that it is a sufficient showing, especially when these things are based on equity principles. I believe it's a sufficient showing of change in circumstance to say, hey, we've been in litigation for 7 years. So the trial court initially, based on these affidavits that were filed, might have believed that there was going to be some kind of evidence at some point put forward to support this tortious interference claim based on these enjoined statements. Right. So he might have had an honest and earnest belief in that 7 years ago. But 7 years of litigation, when we've specifically requested all evidence, all documents, all information that they have to support that claim, and when they presented absolutely zero evidence to support it, I do believe that is a sufficient change in circumstance. And then I would just refer you back to the Planned Parenthood case, which was on a motion to dissolve injunction that the Florida Supreme Court was reviewing. And they were reviewing specifically the DCA's holding that you had to show a change in circumstance, and they specifically said that you're not required to show change circumstance when moving to modify or dissolve a temporary injunction if you're arguing that it was a misapprehension of the facts or a legal error. So I do understand what Your Honor is saying. I think that what the Florida Supreme Court said is that because it's based on these equity principles of fairness, that when you're making those arguments, that you're permitted to make them on a motion to dissolve. You don't have to necessarily show a change in circumstance. But again, I think these things are looked at very broadly because we want these kind of injunctions that are entered so preliminarily to be freely reviewed by the courts. I think that the change in circumstance, again, can be sufficiently shown by saying, hey, you might have thought that this was what was going to be shown at the time, but now we have all their evidence. We have everything that they can show.
But was that a misapprehension of the facts? Because as I understand it, what you have to argue is that the trial court at the time the injunction was entered misapprehended the facts. But it doesn't sound like that's what you're arguing. It sounds like you're arguing, well, you know, we have a more fully developed record and the plaintiff's claims just don't pan out based on this more fully developed record. But that's different than saying the trial court at the time it entered the injunction misapprehended the facts.
Yes,
Right.
Your Honor. And I apologize. So what I'm trying to say is, I guess I am arguing two different things. I'm saying at the time, I do believe that the trial court misapprehended the facts and did not apply the law properly, because I don't believe that those affidavits that just kind of included bare legal conclusions sufficiently supported this temporary injunction. Then on the other hand, I'm also saying now we have this change in circumstance where we say the record has now been developed. We have everything that they can show. And it is very clear from the record before the trial court that they have nothing to demonstrate any deleterious effect on their business from the enjoined statements, which is, again, referring to the plaintiffs as mafia-like, referring to them as bullies, or linking, tagging, or associating any prospective or current customer online with the plaintiffs. And Your Honors, I see that I'm out of time, so if I could reserve my remaining time for rebuttal.
You may.
Thank you, Your Honor.
All right.
Okay.
Counsel, Mr.
yeah.
Ryan, you may proceed.
Thank you. Two things I want to clear up right off the bat. Mr. Levy has said that there needed to be a motion to compel, and he's tried to, I guess, bootstrap that to the fact that he believes the plaintiffs have been dilatory. And Mr. Levy knows very well that at the time that he did that request to produce, prior lead counsel Michael Crosby was having some serious health issues, and that the production was sent after I got involved in the case to try and step in and pick up the slack. And they were not minor health issues. They eventually led to Mr. Crosby passing. So it was a serious situation that had nothing to do with the plaintiff being dilatory. He also made a comment that there's been no depositions in this case of the defendants. And that's true. But what he failed to tell you is that we've been trying to take their depositions. We asked for dates in July, June and July. They pushed them off until September 9th and 10th. Yesterday, we were supposed to be here in the Lake County Courthouse taking Anna Jurovan's deposition. She did not show up on Sunday evening. She had an 11th hour health issue. This morning, we're going to finally be taking Mr. Jurovan's deposition if he shows up. But I don't have confidence that he will. I'm hopeful that he will, but there's been numerous times that we've tried to do discovery with Jurovan in other litigation. There's been a lot of it. And twice he's been found to be vexatious litigant.
Now, counsel, would any of this discovery or any of these depositions, are they calculated to lead to evidence in support of the damages element of your tortious interference claim? Doesn't sound like any of those would.
No, the depositions that he said that we weren't taking of his client are really aimed at showing the fact that they didn't have any factual basis for the claims that they were making against the clients. But with regards to the evidence on damages, the production is one form of evidence. There's a number of forms of evidence. People can come and testify. You have witnesses, you have depositions. And they did a request to produce. And so the plaintiffs produced records, and there wasn't an evidentiary hearing about them. There wasn't an evidentiary hearing with regards to other evidence, testimony, and so forth that would show and continue to support that, yes, there are actual damages. But I would go back and say there's a big distinction between a motion to dissolve where there's been an injunction issued without an opportunity to be heard and without evidence to begin with. And in here, he's trying to bootstrap and say the original injunction was error, and so therefore we should dissolve it. But there was an evidentiary hearing before the injunction was entered, and he hasn't set an evidentiary hearing to dissolve it and present this new evidence or to have the court fully vet it. And he has no record of what happened at the non-evidentiary hearing where that evidence was discussed.
Mr. Ryan,
Yes.
is the fact that it's been described and it's titled a temporary injunction has been in place for 7 years certainly seems like to a non-legally trained reader, temporary should be less than 7 years, I would think. Isn't the fact that it's been in place for 7 years, could that be considered by the trial court as a change in circumstances? I mean, you're describing to us discovery that you're saying should have taken place even now up to yesterday and today. To me, that certainly sounds like there's not a whole lot of work taking place on this case until you're up against a time constraint, albeit maybe an oral argument in front of the appellate court. So, should the trial court be able to consider that as well in an evidentiary hearing as far as a change of circumstances?
I think that as part of an evidentiary hearing, the court has broad discretion to do justice. And I think that they probably could, but that's not what happened here. And with regards to what might appear to be waiting until the deadline of an oral argument to take depositions was actually caused by Mrs. Durovin being added as a party and then twice going and file her own Chapter 13s and dismissing them when the stays evaporated. So we've had a number of delays that had nothing to do with waiting. We're very close. The case is ready for trial, and the court's been notified of that. If I had been lead counsel on this case from the beginning, I think I probably would have tried it sooner. But in addition to the fact that there's been time for legal process and the types of problems that courts have to deal with all the time, including a pandemic in this case, the defendants have done everything they can to slow this case down, whether it's trying to get a cooperative date for a deposition or a cooperative date for a hearing. And the procedural tactics that they've used, including 5 appeals, including a number of motions and so forth, but the lack of cooperation to get things really focused. And let's look at this particular instance. We've told them in a number of other appeals, we need to have an evidentiary hearing. How hard would it be to schedule an evidentiary hearing and see whether or not the evidence really supports ending this injunction? That hasn't happened. It's a very simple process. You ask for an evidentiary hearing, you come in, and then the plaintiffs would be able to show more than their document production. And when it comes to proving damages, they're entitled to do that. They could bring in witnesses, they could bring in real estate agents, they could bring in potential buyers that didn't buy. Their statements could be produced into evidence. So that hasn't happened here. And yes, 7 years seems like a long time, and the wheels of justice sometimes don't move as quickly as we would like, and sometimes it's the party's fault.
Well,
But
Mr. Ryan,
I think
do you and your client bear some burden or responsibility for at least a portion of that 7-year delay and moving this through to a trial?
I can't speak to what happened in the case while Mr. Crosby was lead counsel. For me to sit here and act like I know everything that he did, I'm looking at the docket and I study it, and I think I would have done things a little bit differently. But I also think that Mr. Crosby was doing a very good job in trying to be diligent. But you can't move forward when there's bankruptcies and automatic stays. And we've had 4 automatic stays in this case.
So, Mr.
Sometimes
Ryan,
during appeals, you have to wait.
regardless who bears responsibility for the now 7-year delay, if we want to characterize it as a delay, going back to the point, a temporary injunction, just intuitively, that has to mean something. It's temporal. It's not an eternal injunction. It is a temporary one. Is there some quantum of time, putting aside, who bears responsibility for the delay, but is there some quantum of time at which, there's just a hard stop that, the injunction has to be dissolved because it's just been too long? And that there can be another evidentiary hearing, and whether or not there needs to be a new temporary injunction can be decided. But is there any portion of time, or would you say, well, no, I mean, as long as we're doing our minimum due diligence to move the case along, if the case progressed for 10 years, 20, right? Would you concede that there's at least some theoretical hard stop, or are you contending that there's not?
I've never seen any case law supporting that position. In my entire practice and my entire knowledge of the body of case law out there is that temporary injunctions last until further order of the court, and typically until the trial on the merits. And that when that becomes unduly burdensome, there's a procedure that requires an evidentiary hearing. But other than that, yes. And with regards to the burden on Mr. Jurobin created by this injunction, tagging specific people is not the same as standing on the sidewalk with a sign in front of a car dealership. It's the same as going in and tapping on the car dealership's customer's shoulder and saying, hey, I'm talking to you, customer.
Sure,
So
but do you concede, though, Mr. Ryan, that if at the end of the day, the defendant proves that there are no damages, that there's been no interference with the business relationship, at that point it would be protected speech, right? If your claims fail on the merits, and if all you have is the speech in which the defendant was engaged, and if there's, at the end of the day, and I'm not saying that this is going to be the case or it is the case, I'm just saying as a hypo, there's no tortious interference, then we would be dealing with protected speech, right?
As far as the temporary injunction, yes. I think when it comes down for a permanent injunction, if you prove the defamation, I think there's some things that you can still protect.
Sure, but as far as the injunction, as far as the prior restraint.
Correct.
Right.
Yes. I'm sorry, I'm not sure if you heard me. I said yes.
No, I heard you. Thank you.
Okay. So I think the most important thing to take out of this is that the rules are what they are. None of them are perfect. We all, as practitioners, work with them, but they're pretty darn good, and they've been developed over many years with a large body of law to go on. And here, the court had a procedure. It used its procedure. It made findings of that, and in order to go back and challenge it for being error to begin with is different than what we're doing today. What he's saying is that I've got new evidence. And I want to present that to show that the injury won't be proven. But he hasn't had an evidentiary hearing. And that's just the wrong way to go about it. If he wants to test and see whether or not, after all these years, we can now prove definitively that there are actual damages, he needs to give us, give the court a chance to hear that evidence, not just what's the documentary evidence. People's testimony is important too. Thank you.
Thank you. All right. Mr. Labby, you have 4 minutes and 16 seconds.
Thank you, Your Honor. So I just want to address a few things. Mr. Ryan continually referred to the fact that there wasn't an evidentiary hearing. That is not a requirement to dissolve or modify an injunction. There's never been a single case holding that an evidentiary hearing is required. There's an evidentiary hearing is required when imposing an injunction initially, but not when dissolving an injunction, not when modifying an injunction. And just from a practical standpoint here, what would we have done in an evidentiary hearing? Say, Your Honor, let's have an evidentiary hearing. And then I go there and I say, there are no witnesses, there is no evidence. Because
counsel, you could have brought the now presiding circuit court judge up to speed on litigation that's taken place over 7 years. I'm certain it's probably a different judge. So don't you think there was some value in presenting at least some evidence to the trial judge?
Your Honor, we did present that and argue about the length of time that it's been going on. That's not really evidence necessarily. It's more looking at the court docket. I certainly did make that argument in the motion to dissolve and at the hearing for the trial court and said, listen, all they've done, the same thing I argued today, all they've done is amend the complaint over and over and over again and seek to enforce the injunction. But as far as, Mr. Ryan said, well, they could have brought in these people who didn't go through with their purchases because of Mr. Jervin's statements. First off, they would be the party who should have that information. If they had that information, they should have produced it to us. And I certainly would have sought to depose those individuals, but they've not presented a single person who ever said, I didn't go through with the sale because Mr. Jervin contacted me directly. Mr. Jervin tagged me in a post. Mr. Jervin referred to them as bullies or referred to them as mafia-like. And again, it cannot be communications to the public at large. They have to show that these people were contacted, that he specifically contacted them for the torturous interference claim. And if you look at those emails and those text messages, it could not be clearer that that just never once happened. It just never happened. So I suppose I can say that I did depose everybody who ever backed out of a sale because of Mr. Jervin's online statements, because the answer is none. There's never been any evidence of that. So that's as far as the evidentiary hearing. And then Judge Wallace, just to your point, and that is something I should have mentioned in my initial, was that's another change in circumstance besides the fact that there's been no evidence in the 7 years and that we've asked for this discovery and that clearly doesn't exist. The fact that it's gone on for 7 years is a change in circumstance that the court can consider in dissolving or modifying an injunction. So to the extent that we are required to show that, that certainly is another change in circumstance on top of the fact that it's now clear that there's no actual evidence of any torturous interference based on the enjoined communications. And Your Honors, I would just again say, there was kind of a comment of, well, talking online isn't necessarily the same as, First Amendment speech is First Amendment speech. And Judge Pratt, you are correct that at certain points, speech is no longer protected. There is no evidence here that we have got close to that standard. And again, these types of prior restraints are the most serious and the least tolerable infringement of First Amendment rights, which is most important. So, to impose that for 7 years and ongoing, with no evidence of any actual harm, no evidence that this speech should not be protected, I believe is just wrong, Your Honors, and the trial court erred in denying the motion to dissolve.
All right. Thank you, counsel. The case is well argued. And at this point, we will stand in recess. Have a great day.
Thank you, Your Honor.
very much.